Next, we'll move to item 17A, which is the consideration and adoption of the resolution number 3, which is resolution of the Vacaville Unified School District declaring its intent to transition from at-large to trustee area board elections. And I believe we have attorney Ryan Tung from Lozano Smith.
Right, good evening, everyone. My name is Ryan Tung. I'm an attorney for Lozano Smith, and I'm here today to talk about the California Voting Rights Act. And I will do my best to keep it brief. If I keep going, just tell me to wrap it up. So, as you may know, in early August, the district received what's known as a demand letter, essentially alleging that the district's current method of election of its board members violates what's known as the California Voting Rights Act. And the first thing that I want everyone to know is you are not alone in receiving this type of demand letter. Public agencies all across the state, really over the last 5 years, have been receiving these demand letters from plaintiffs' firms that have been looking to make changes through the California Voting Rights Act. So when you receive a demand letter like this, there are certain safe harbor provisions in the Elections Code and in the Education Code that give districts some leeway and some protection from potential CVRA litigation. And so tonight what I'm hoping to do is give you a little bit of a primer on the California Voting Rights Act and then give an overview of what those safe harbor protections are and what you can do now if you want to take advantage of those safe harbor protections. Okay? Great. So we'll go over the California Voting Rights Act and then the process to transition to trustee area elections. So currently the board is elected at large, and all that means is that any registered voter in the district can vote for any board member regardless of where the board member lives and regardless of where the registered voter lives. So if we take a look at this graphic here, and the blue is the registered voter, and we'll say that the red are board member candidates, the board member candidates can live anywhere within the district boundaries, and any one of those registered voters can vote for any one of those board member candidates regardless of how far away they live from those individuals. And this has been a common practice for a lot of school districts. But in 2002, the California legislature expressed some concern that this at-large method of election, at times and in certain circumstances, could impair a minority's ability to elect candidates of their choice. So in 2003, I believe it was enacted, the California voting rights came into play. And there's a lot of lingo in there, but at its core, the California Voting Rights Act prohibits the use of at-large elections that can do either one of two things. Either impair the ability of a protected class to elect candidates of their choice, or it states broadly to influence elections. So really, what term you'll hear thrown around a lot in CVRA talk is racially polarized voting. And really what that is it's a really complex statistical analysis, but it really just determines whether these 2 points have occurred. I'm wondering how to use the... There we go. These 2 points have occurred. The one thing that I do always want to point out when I'm talking about the CVRA is when a case is filed, and if a court determines that racially polarized voting has occurred, so these at-large elections have resulted in one of these two impairments, proof of intent is not required for a CVRA violation, meaning that the district, it's not a defense to say this may have happened, but we didn't intend for it to happen. So that is not a defense. Realistically, public agencies have had a hard time in trying to fight CVRA litigation. In fact, I'm not aware at this time of any public agency that has fully and successfully defended themselves when a CVRA lawsuit has been filed against them. And one of the main concerns and considerations with a lot of public agencies is the actual cost to fight these CVRA litigation. As I said, racially polarized voting is a very complex statistical analysis. It ends up costing a lot of money in demographers' fees and in attorneys' fees. And the kicker in this is, in many cases, the public agency that's fighting a CVRA lawsuit will also be on the hook, in many instances, for the attorney's fees of the plaintiff who's suing the district. So I don't want to go too much into these, but I just wanted to highlight some examples in the past 10 years or so of different public agencies who have determined to fight. And of course, each district has their own scenario of what their at-large elections were or were not doing. But these are just an example of the payout that was given just to the plaintiff's counsel in these litigation costs. There we go. So now we know a little bit about the CVRA. Now we know a little bit about CVRA litigation. There is one specific method of election that the California legislature essentially said is exempt from CVRA. So if you adopt this by-trustee area elections, you are per se in compliance with the California Voting Rights Act. So that's why you see a lot of districts or public agencies who are served with these types of demand letters making the consideration of whether or not to move to trustee area elections. And that's what's in front of you today. It's a resolution, and we'll talk about that a little bit more in a little bit, that would signal the board's intent to begin the process to move to trustee area elections. And I'm going to apologize from the front end. I use by-trustee and trustee area and district area interchangeably. They all mean the same thing. And what they mean is, in a by-trustee area election system, trustees or board candidates must live within their specified trustee area, and only registered voters who live within that trustee area may vote for that particular trustee. All right, so when the district receives a demand letter, I said there are a couple mechanisms that the district has at its disposal. This was actually a recent update, probably 3 or 4 years ago, where they updated what we call safe harbor periods. And I like to call them safe harbor period 1 and safe harbor period 2. Right now, you are in safe harbor period 1. So when a demand letter is served on the district technically has 45 days where the plaintiff who filed that demand letter is not allowed to go to court and actually file CVRA litigation. So at this point, CVRA litigation has not been filed. We just have a demand letter. If the district within that 45 days decides to adopt a resolution of intent, which simply says, as I said, the district intends to transition to trustee area elections, if that is done within that 45 days, then there's an extra 90-day window. So the plaintiff will then be precluded from filing a CVRA lawsuit for another 90 days. And so that's the consideration that's in front of the board tonight, is that intent resolution. And one other thing that I want to mention is written within the statute is if the board does adopt the intent resolution tonight and decides and goes through and makes the transition to trustee area elections, any plaintiff recovery would be capped at $30,000. So that was a recent inclusion based on the sort of the really high attorney's fees numbers that the legislature was seeing through the CVRA. I see a lot of shocked faces on that one. All right, so we now know what's in front of us. It's a resolution signaling intent to move to transition or transition to trustee area elections. But what does that process actually look like? And I'm going to warn you from the front end. The process for school districts is harder than other processes for other public agencies. Due to some caveats in the education code, there's a couple extra steps that we'll have to go through if we decide to make this change. So what I've tried to do is I've broken it down into 4 steps to hopefully make it as digestible as possible. So step 1 will be district adopts the intent resolution, which the board will deliberate about tonight. And again, as I said, if that occurs within 45 days of receiving the demand letter, and I think the 45-day deadline would fall at some point next week, which is why it's brought in front of you today. Then, if this is adopted, the board will have an extra 90 days to complete this transition. All right, step 2. As I said, the legislature recently adopted sort of cleanup resolutions or legislation, excuse me, that included and required the districts to have a certain amount of public hearings. And that public hearing requirement used to be 2 or 3, I think, but now it's 5. And so what those public hearings are is the first 2 are what we call pre-map public hearings. And essentially what happens there is the board will take public comment about what the public would like to see the trustee areas look like. Then after that pre-map hearing, or both of those pre-map hearings, the district's hired demographer will take all that information, put it together, and put together usually 3 to 5 draft maps. So trustee areas that look different shapes, different sizes, based on the public comments that were given. Those will be published, and then the board will have 2 what we call map consideration hearings, in which you'll take a look at those maps, you'll be able to discuss it and deliberate, and then the public will have the ability to comment on those maps as well. And then the 5th public hearing is the map adoption hearing. And that is you will take final comments and then determine which map you would like to adopt as the trustee area map for your new trustee area elections, should you choose to move forward that way. Step 3, and this is where school districts differ from other public agencies. A school district's adoption of a map and trustee area elections actually isn't final approval needed. School districts actually have to submit that as a proposal to the County Committee on School District Organization. And it is, so the county committee in this county is actually the County Board of Education. So based on some education rules or education code rules, some counties have the ability, or all counties have the ability, to have a separate county committee. A lot of them, just for efficacy's sake, will end up serving as the county board and the county committee. So when the county committee receives that proposal, they're required to hold 1 public hearing within the district, and then they'll either vote to approve or deny the district's proposal. Again, this isn't the last step. So there's one more step on this. Technically, by versions of it's ancient language in an education code. So really, when the county committee approves, that approval actually becomes what's called an order of an election. So that question of whether to move to trustee areas or not, by the education code, would actually be placed on the ballot as a measure. Now, that comes with associated cost and associated time. And as we talked about, the district board is really within a tight time frame to try to get these things done if they want to avoid CVRA litigation. So what an overwhelming majority of school districts do is they seek a waiver from the State Board of Education of that election requirement. And to my knowledge, the State Board has approved every single one of those requests that has been submitted. Okay, happy either way. So what I have done is, based on that 90-day timeline that we've sort of talked about, if the district decides to adopt the resolution of intent tonight, and based on those steps that I've talked about, this is what a potential timeline could look like for those steps. So tonight would be the adoption of the resolution of intent. In October would be the 2 pre-map hearings. The statute also does not require, but it permits the board to hold community meetings. If the board determines that extra outreach would be beneficial or necessary, they can hold community meetings as well, which are very much less formal. They're not board meetings. They're inviting community members to come and just have a conversation. And if the board determines that it wants to move forward with the State Board of Education waiver, the district would hold a hearing on that waiver at some point in October. And the waiver part is not something that the board needs to decide on tonight. That'll come back at a later date. And then in November, after the demographer has created and published the maps, there would be the 2 map consideration hearings. Late November and December would be the hearing to adopt the final map. If possible, our request would be that the county committee hold the hearing on the proposal at some point in December, likely in early December. And then the State Board of Education would hear the district's waiver, likely in January. The State Board, it usually takes 2 to 3 months actually to get a matter on the State Board of Education agenda. So that's why we have that set for the January, or estimated for the January meeting. And then if that's all finalized and approved, then in November 2020 would be the first election of board members by trustee area elections. So that's what the estimated timeline would look like. And I'm just going to have one wrap-up slide. These are some considerations that I'd like everyone to keep in mind. It's questions that I get fairly often when giving these types of presentations. One, when you transition to trustee area elections, if you choose to do so, the terms of current board members are not affected. So if you were elected in 2016, you still get to serve out your 4-year term. So no matter where you are drawn in the trustee areas, as that is playing out, your current term is not affected. Second, and lesser known, is that in the education code, when trustee areas are adopted, after every census, there has to be an adjustment of boundaries to account for the population growth. Now, rest assured that that change in boundaries is a much, much less burdensome process. District board gets full control over that. And then when a transition to trustee area elections occurs, the district boundaries themselves do not change. There are just trustee areas that are drawn within those specific boundaries. So that's my presentation. I'm happy to take questions if you have any questions.
I have a few.
Yeah.
Hopefully they all make sense. Okay, so I guess I want to get some clarification on what the community input looks like, since there's guidance and rules around how the demographer has to build the maps for equity and for like the conditions and requirements.
Yep.
So is that like education happen at every community meeting so that then the community can
Yeah, so
educated? I mean, because they can't just say, I want this, because there's some guidance that we have to do, right?
So generally how it plays out is if the board does adopt this and we go to that first pre-map public hearing, the demographer will come and give a big presentation about all the different things that can be considered and take questions. And then to the extent necessary, the demographer could also be at smaller community public meetings if the board wishes. That's something that has happened in the past if questions arise. So the demographer really, and we've worked with this demographer before, is very, very good about explaining what all the different criteria can be considered are.
Okay, so it's a part of the meeting. Okay.
Yeah, and it'll be part of the process. Well, it'll be rolled in.
The other thing is, there's the ballot idea. So which one has final, I'm trying to figure out how to ask the question. What if we did all the work and we took the option to go to the community to say, how do you really feel about this? And they said no, or yes, or like they could validate it, or they could say, yeah, not interested. Does the CVRA still trump the community vote?
Yes, if it ends up going to the electorate, and and that's after county committee approval and board approval, and it goes on the ballot. If the voters do vote it down, that is not protection under the CVRA.
It is not.
It's not protected under the CVRA, no. So it has happened in the past where it has gone to the vote, it has been voted down, and then a CVRA lawsuit was filed and settled right away. So that's happened before. There is, I can't remember the name of it off the top, and I wouldn't want to guess on details.
Okay, that's fine. And then, so then the fiscal implication, because of our timeline, because of butting up to the potential impending census change.
Yes.
Is there? I don't want anybody to think I'm against it. I'm just really trying to pragmatically understand.
Absolutely.
Like, if we're going to have to pay for a demographer back-to-back years because of our process, even though it's going to be less intensive and less expensive on the second round, it's super soon. So, do we just need to be proactive and build it so we don't have to worry about it, or is there a way to buy time so that it's efficient? Like, get a waiver for that because of the proximity to the census.
I have not seen a waiver request to waive the census adjustment requirement.
Is that an option? Does that exist?
So in the education code, there's the waiver section, and it says which particular codes can be waived and can't be waived, essentially. So it's very permissive. I'm racking my memory, and I can't think of that as being one that can't be waived, but that doesn't mean it will get approved by the state board. So I don't want to tell you that it's not an option, because some more research on that, or can I put a request in to Absolutely.
Get some more information? No, really, because I just want to fully understand our options. Because if we're facing budget cuts and we want to do this right,
that's a great question.
It's all, and then the election's also that year, and then you have a change. Heaven forbid something wonky happened, and then we're back to square one. It's
a great question.
Cool, thank you.
So I'm trying to understand some logistics. So let's say that we draw a district, right? Let's say we draw 7 districts, and one of the districts has 2 people that are currently serving a term in it. So it's 2020, and there are 2 people that are due in 2022. So what happens?
So, and I'm just going to repeat this to make sure that I have the question right. You have 2 trustees that are drawn into one trustee area. they're both set, their term is set to expire in 2022.
Right.
And trustees come up for election in 2020.
Right.
So the first thing is the board will have to put together a proposal of what we call the staggering schedule would look like. So usually you want to implement it on 2 election cycles. So 3 board members will be in 2020, or maybe 4 board members in 2020 and 3 in 2022. When you recommend that staggering schedule, technically the county committee has overall approval of what that would look like. But in my experience, usually when the district proposes something, the county committee will approve. Now, if that seat was, this gets a little bit complicated, so I'm gonna, if that seat were to come up in 2020.
Well, it does, if that district.
Yeah, sorry. If that district, if the seat in that district were to come up in 2020,
Right.
then the board members, practically speaking, could either stay on the board for 2 more years and then wait until 2024 to run, or could possibly resign and run in 2020. More likely, if you have 2 trustees that are in that trustee area that are up for election in 2022, that trustee area would not be up for election until 2022. So it would be a sort of an off cycle.
Okay. And so a sister question to that is what if there's somebody from 2020 and somebody from 2022 in a single district and it's 2020?
Yes, and so you'll probably have to play out the same permutations where there will be a proposal about when that trustee area will be up for election. So if it's determined that trustee area will be up for election in 2020, then the person who is up in 2020 will run as regular.
What about the person that's already in that district that term goes till 2022?
Then they will probably personally have to make a decision as to whether they want to complete their term and then wait 2 years to run again, or resign their seat and run.
But it says it's in terms of current board members not changed by transition to by-trustee areas.
Yes, so the 4-year term cannot be shortened,
right,
based on this, but a board member can elect to do so if it makes sense to them.
But what if they don't? So what if they say, no, I'm until 2022 and I'm in this district?
Yes, so there's some minor hurdles here, but really what happens, and the way I see it, is that everyone who has been elected at large is still an at-large seat. So in 2020, what's going to happen is you're going to have a split board where you'll have 3 trustee area board members and 4 at-large board members.
Okay, so
the opposite.
So in other words, you're saying that district could go up in 2020, and that person would just keep their at-large seat until 2022.
Correct. If they were elected in 2018.
Right.
Yes.
Okay, that makes sense.
Are you sure? I have to just soapbox just for a minute, and then I promise I have questions after.
Absolutely.
So the letter came addressed to me, the Hispanic person on the board. And so it's just, we have an election happening right now with 2 African-American ladies and a Hispanic gentleman. And so it's just a very frustrating thing. I've gone to the Philippines the last couple of years, and I go and I do social service work over there. And I love that country, and I love the people. And they are a third world country. And my experience there is we as the state of California are now taking a lesson from the country, a third world country, in how they do their politics. And what I mean by that is they have big cities, and then they have barangays within the city, and then you have a captain of the barangay. And so that captain is elected by those people. And so when they're going to do large government, all they care about is the people that put them in office in their barangay, because that's how they're going to keep their position. And that's what they need to do. That's who put them there. And so instead of having a government where we're looking at what's best for our whole community, we're now isolating. And so the people are going to now have the back of their district, because those are the people that put them in office. And so we have a board now that we knew we had a need at Markham. And so because we could sit back and have a collective voice of what's best for our community, we took money and we moved it from one place to another because we had a need as a community. And so the state of California has taken our ability to do what's best for our community. And it is just the most devastating thing that has happened to education as far as I'm concerned. And we have taken a state that already, we were the shining example, and then the government came in and destroyed that for us, and here they come yet again, and they're taking what is left. And so, done with that, and so now the state has demanded us do this. It's going to cost money, so the state is now stealing from our students yet again, because now we have to pay for the demographers and the attorneys, and yet there's no compensation from the state of California in order to do what needs to be done. So, with that said, as far as the council goes, our city council just went through this, and so their mayor still sits at large. So, as a school district, do we have the option of having a couple positions that have a different title that sit at large? So maybe we have 4 districts and then 3. You know what I'm saying? Is that possible?
Yeah, so it is possible, but it's likely not protected under the CVRA. So you may be subject to the same type of challenge. So as written, the CVRA defines at large as a number of things. At large, I put it up there as a simple graphic. It's not just that graphic that I showed. The definition also encompasses the consideration that you were thinking about, where you may have multiple trustee areas or multiple trustees sitting in different trustee areas with different voting schemes and schematics. The only thing that's really truly 100% protected as written is what I call the true by-trustee or trustee area elections.
Would we be covered if the board president was an at-large position?
Again, it would be the same response, where there's not a guarantee. Based on the way that the statute's written, if there's anyone at large, the entire district is considered at large.
So how does the city not have a liability then when the mayor's at large?
I think there are different city rules and ordinances with respect to the mayor itself. I'm not 100% sure, but that's my understanding.
Okay, thank you.
You're welcome.
So I guess I just want to piggyback, because I agree with what Sheree just said. I think it's important for the community to know that this is not a new law. It's been on the books for over a decade, right?
Yeah, like 15 years.
So the sad part is that an attorney saw an opportunity to make a really good living, because this law is not enforceable until you're sued. And so if you look it up yourself, make your own educated decisions about how you feel about it and how you think it'll affect our community. But at the end of the day, many of the districts and municipalities who have made this change, it did not have and has not had the intended outcome. So the protected populations, who we all, I think, at least I can speak very safely for the team here, is that we really truly understand that we have a responsibility we're beholden to our whole community, all of the people that we serve, all of the students that we serve, and that equity is a challenge. And so we have to be very mindful of that. We're responsible to that. I don't know that this is, at this point, if a person wants to run, they have 7 opportunities. And now moving forward, they're going to have 1, depending on where they live, and still may or may not have the means, still may or may not have the moxie or interest. I don't know that this is one of those laws that doesn't predict that it's going to have the intended outcome. And to Sheree's point, it's really, really a step backwards for how we do business. And so I really just want to make sure that I understand, just to what Michael was asking, so that the community understands, is that if someone is elected now, this year, like in our election now, and then in 2020, there's overlap in that area, that person completes their term, and I think what you were getting to is they could run again in 2 years, is they complete their term, they're stepping down because they're not going to rerun when their term is up. Another person would then sit up, and then they would have to run against the person who is in their area from the 2018 election. So
do you mind if I clarify that just a little bit?
I don't mind if that's okay.
Yeah. So if they're elected in 2018 for a 4-year term, and say their trustee area comes up in 2020, they can continue their term, you're absolutely correct, until 2022, or they can decide practically if they would like to resign their seat and run for the seat in 2020.
So can I ask one more follow-up question then?
Absolutely.
Does that mean that the person who's running, so for the person who is in the 2020 cycle, would they have to step down because there's already someone seated from the previous election, or because of the staggered way it works? Those 2 things could happen and it would resolve itself in 2022.
So if the individual was up for election in 2020, then they would be running for that seat as well in 2020.
No, I understand. That's what I'm saying. But the person who may already live in their area, for example, who was elected in 2018, doesn't preclude them from running in 2020.
Correct.
Okay, so it resolves itself in 2022.
That's the hope.
Okay. I still really want that waiver information.
So, Mr. Whitman, I think you have your light on. If you don't mind, though, we have a card from a speaker, and I also have two people that sent in comments they'd like to have read. Would you mind? No. Okay. Julia Hahn, would like to come up and speak? And we ask that you keep it to 3 minutes, please.
Okay, absolutely. Okay, so essentially my biggest concern with districting is actually not what you guys are speaking about. I have seen a lot of community input, and quite frankly, there is a desire for this. It just happens to come from the minority communities that get outvoted because they're minority communities. So, essentially, my biggest concern with this whole entire process is having community input. And I feel like we got to it a little bit late with the Vacaville City Council districting. And one of the things that ended up getting brought up in the end was that they only had input from 80 people. Now, I thought getting 80 people to weigh in on whether or not districting was a pretty darn good number. But honestly, the amount of community outreach that is possible is much more than was actually done during that process. And what I would like to see is a lot more informal meetings, because quite frankly, coming up to the dais and talking about things is not exactly the easiest thing for a lot of people. Having that be an important foundation for what exactly is considered communities of interest, et cetera, as I'm sure the lawyer and the demographer will get into. But that is really important, and I think it's really good to take a look at this very early stage to start planning, because quite frankly, as much as you want us to do it in 2022, or for the 2022 election, these laws tend to be pretty cut and dry. So, I mean, there may be a waiver, but there may not. So thinking about the community outreach now, thinking about the process now, how are you going to get people to actually come together and actually give some sort of input? Because quite frankly, it is really, really important. And I can send out all of the Facebook invites that I want to, but I only have so many Facebook friends, and then I'm only getting the people that I know. And quite frankly, that's not all of Vacaville. That's not all of Vacaville Unified School District. And I think it's really important to get that community engagement really early and really thoroughly.
We're working on a plan. We've already discussed it, so we have a great communications person, and we're working on a plan.
Okay.
Yes, we are.
No,
Yes,
I believe you.
We're going to be out at sites. We're going to be talking to people. We've done this before, so we're working on a plan.
Okay.
Yeah. And they're informal meetings, not formal board meetings, informal community meetings. Yeah.
Thank you. The other thing that I would like to say, and I know I probably don't have very much time left, but if you are using the same demographer as before, I feel like he actually did a really good job. So that's my personal input.
Ma'am, may I ask what section or area of town you live in?
I no longer live in Vacaville, but I am a representative for the Northern Solano Democratic Club, which represents a lot of people that live in the city.
Thank you.
Okay. If you don't mind, there's two, I'm going to read these real quick. There's two people that sent in comments that they wanted to be read. This first one is from Michael Silva. He's a professor at Solano Community College, and he said, I'm unable to attend the school board meeting on 9/20. However, I would like to express my support and encourage our trustees to adopt a resolution declaring the intent to transition from at-large to by-trustee area school board elections. So that's his comment. And the second comment is from Thomas Hall, and he says he's writing to express support for a move to district elections for the Vacaville Unified School District. More than just a defense against a threatened lawsuit, VUSD should embrace this as an opportunity to ensure all students have strong presentation on the board. To that point, the City of Vacaville district lines, where they overlap with VUSD boundaries, should provide a guide moving forward. Diverse representation is crucial. Thomas Hall. So those are the two I have to read. So, Mr. Whitman, I believe you're up.
Well, first off, I'll go back to the letter that it was Mr. Shankman as the attorney, correct?
Correct.
And he's filed numerous lawsuits throughout California.
That is correct.
I would describe him as a vexatious litigator. It's a legal term, and if they actually apply it to you in court, you can be fined or disbarred and a whole bunch of things. Mr. Shankman, as you implied, there are 1,000 school districts, maybe some other cemetery districts, et cetera. He could go after 450 cities. He's making a good living at $30,000 a pop or more off all these districts. I resent that to start with. Secondly, in his letter, as Mrs. Malberg said, he stated that there was no Hispanic representation on our board. That's outright wrong, and he put that in writing in his letter. Really makes me angry. Obviously, he didn't do his homework. The guy's a cheap shot artist, a drive-by shooting. We have 1/7 of our board is Hispanic. That's about 13%, give or take, right?
Give or take.
Give or take. There's about 17% Hispanic registration, not registration. It's persons of voting age is the correct demographic. Is that right?
Citizens of voting age population.
Citizens of voting age, not really registered voters. But that's about 17%, correct?
Yes.
All right, 13% in my book is pretty close to 17%. We would seem to fall, in my estimation, within the limits of what would be reasonable representation. I talked about the 30,000. Do you know if SB 1250 has been signed by the governor?
SB 1250. If I'm remembering correctly, is this the one regarding residents of legislatures? I'm not sure that it has been signed in, but I don't believe it would apply here.
No, it wouldn't apply, but it surely stinks when it's SB 1250 says that a state legislator, whether a senator or a representative, does not have to reside in the district that representative represents. Why are we going to trustee districts in which you have to reside when our state people don't have to do it? This doesn't correlate. It's wrong to make us do this, and then the state says, we don't have to do this. You mentioned community of interest, or actually one of the speakers mentioned it, the lady. How do you define a community of interest?
That is a great question, and there's no, from my understanding, and that would be a question probably better served for the demographer who works and helps define those communities of interest. But what I have seen in the past are different communities that seem to be like-minded, different communities, city lines sometimes is where we see it. It's a very, very broad and amorphous term that usually gets defined and sussed out a little bit more during the community input meetings.
But actually what this law wants us to do is draw a map that supports some community of interest. Is that right?
I think that is part of what this law, the legislature was likely intending when they were writing this, yes.
So we're going to protect the right of the minority when we've always gone by majority rules. So we're changing the playbook.
The legislature, when they were writing it, and I wasn't in the room, but from reading the legislative intent.
It's your fault.
The legislative intent was to, and if I read it correctly, to provide minorities a stronger voice than they had previously, or that was exhibited previously.
And there's enough minority citizens of voting age, I think it was, is that right?
Yes, citizens of voting age.
All right, there are enough in Vacaville that if they chose to vote for somebody, they could elect somebody in an election already. They don't have to have a district. If they went out and voted, they'd get one. And I don't like that because those people don't people who don't vote probably aren't informed of the issues, don't know what's important, what's not important, don't care enough to vote, and I resent that. I want people that are informed voting and electing representatives, whether it's school board members, city council, state legislatures who don't live in their district. On the waiver, what are the real timelines for that?
There are no true statutory timelines on the waiver itself, but the intent is to finish this process as close to the 90-day window. Most boards' intent in finishing this is to finish the process as close to the 90-day window as possible to avoid a potential lawsuit being filed in state court. So usually what we see is boards who decide to seek the waivers decide that sooner rather than later. And I know that's
Do we decide tonight to seek the waiver or next meeting? Do we have to be anywhere in the process before we can do it?
Generally speaking, when you're submitting a waiver, it's probably a good idea to have an intent resolution first so that you can attach that and you
then
can
you
show.
can seek the waiver right after that.
Yes. There's
I want to do that
You
because
can find where you're talking about the waiver. What is the waiver that you're talking about?
No election.
The waiver of the election requirement is my understanding of what your question is.
No,
I definitely want to waive the election requirement.
yeah, I don't think that's what he's talking about. That's why I don't know what kind of waiver he's talking about.
That's what I'm talking about.
Oh, I was not there either.
The waiver, the election. No, but nobody does the election. Everybody.
Well, but you need a waiver, and you need to get
but
it
that's-
done before the 90 days
Right.
run out.
Oh, okay. I didn't realize.
Right?
So practically speaking, what I've seen, just because of the state board's timelines, is sometimes the actual state board's hearing is essentially right after the 90 days expires. But in our experience, we have seen that plaintiffs' counsels generally will not file at that time because all the process is done. It's almost the last step that needs to be taken. Does that make sense?
All right. That answers my questions. Good presentation.
Thank you.
So, a couple of things. I fully understand and agree with some of what Mrs. Malberg and Mr. Whitman are saying. There are challenges. It does change some of the dynamics. But I think what hasn't been talked about is the fact that, we have 90,000 people in Vacaville. And the people on the way other side of town, they don't know me. Most people don't know all of us. So talking about informed voting, we only get when we ran separately from the other city council and that kind of stuff, we got like 12% voters. Okay, and if you think those people knew who we were, that's kind of a mistake too. They just kind of know people who know people who know people. So the big benefit that people aren't talking about this is that if we have 12,000 people or 14,000 people in a district, you will probably know that person a lot more. You can influence that person a lot more. You can come and try to make a difference with that person. And, honestly, it could be if you are you could be an African-American person that actually the core African-American community doesn't really want in. That's possible too. So it's not necessarily just because you're Hispanic or just because you're African-American. It's like, do you represent the community that you're trying to represent? So I do understand the other side, but I think there are real benefits to actually having representation of a smaller group of people, and you have access to the person that's actually representing you. So I think that's the other side that's actually really important about it.
Talked online. Just briefly, I would like to just come off of what you're saying, Michael, and that is to understand what a board is one we speak with one voice, and each one of us only represents one vote of 7. And so by doing districting, I think what we do is we bring a voice to a certain area that we are familiar with, that culturally we may have more things in common. I mean, I live out in Elmira, and so maybe I understand what it's like to live in a part of the city that isn't the city, that is the county, under county rules, where we don't have the city bus come to us. And I represent that voice. I am at large, but when I'm off the board, there is nobody that understands that the bus only goes to Leisure Town and doesn't come all the way out to the kids there who need to go to Cooper or Vaca High. So I believe that districting gives that voice, and then I am able to represent that to all of this group, and then when we vote, it's more informed because each one of us brings that piece to it. It's just like now when we look at the board and we say, you're from mental health, and you're from the, you're retired Air Force, and you work with seniors, each one of us, and when we look to appoint somebody, we always look for somebody who can bring something else to the board that we may have as a whole, so that more voices can be heard. And so I do believe that districting, that's what districting is about. So I understand and hadn't even thought about all the things you brought up, Cherie, which are really good things. But I think our focus has to always be the students. And I think anybody getting elected to the board needs to always keep that in mind. It's not about the politics. It's not about who votes for us. That's why it's not bipartisan. It's about students, and we represent one voice to the many, so we can all vote. So that's where I stand on it. I'm done.
So I just wanted it to be clear that I think I will only speak for me. So we are we strive ourselves as a board to be very financially responsible, and there's no intention, as we get to call this question of spending money that should be spent on students, on unnecessary litigation. So we do feel like our hands are a bit tied, and that our philosophies and all that at the end of the day is we have to be good stewards for our district. And so we're going to do the right thing. We're not in the business of not following laws. It's really not a question of whether we all believe that people should have appropriate representation. It's really about the unintended consequences and having the ability to make good decisions on a local level and not have these kind of just arbitrary impositions for the state level. Because I agree with what Shelley said. And so all of our personal politics aside, we really want to do what's best for the district. So I would just say that really, regardless of where you stand on opinion, understand that our responsibility is we have a choice, regardless of how we feel politically or not, that it's $30,000 where we protect the district, or it's more. So I think it's kind of like one of those things where, it's designed to go a certain direction. So I would just say if we're ready to call for this question, we could, because then I would want to wait till after this is done to have one other comment. And I just hope that everybody understands that this is the only opportunity we have to tell the community at large, where we sit, what we stand, and hopefully invite you to be a part of this process. I can honestly tell everybody that Jennifer Leonard, Superintendent Shemia, the team, our whole admin team, there is a robust process going to happen in this community process. So I'm super confident that we're going to talk to anybody who wants to talk to us and have an opinion about this. So I think, just rest assured that we are invested in doing it the best of our ability. So can I call for the question? Oh, that's what I'm asking. I just asked the question. I don't have to. If you want to continue to talk, I won't call for the question.
People still have things to talk, and Shelley needs to leave, and she'd like to be part of the vote. If we have next steps after this resolution, we can continue the conversation. I wanted to give Shelley the opportunity to vote. I just was trying. I don't want to dishonor your request. I'm good.
Population 95,000. What's the actual citizens of voting age?
I'm not sure at this point what the actual citizens of voting age population is.
It'd be really nice to know that and divide it by 7, because it's going to come out to maybe 7,000 voters per district, which means somebody will be elected by about 2,000 people. Maybe 3,500 if they get a 50% turnout in that district. Or elected by 6, 7, 8,000. You had 10,000, I think. The number of people electing a representative is going to go way down. And that is not a good thing in my estimation. And I'll leave it there.
Okay, so just I just have a couple of questions. So when it comes to when things go to a district situation, how does that affect appointments? Does that mean appointments have to be someone? So if someone vacates their seat for some reason, does the appointment have to come from within that district? And what if there is no one from that district who applies for the appointment? I mean, what happens then?
Yeah, so if it's a trustee area seat and there's a vacancy, then the appointment process has to be someone from that trustee area. And if no one is provisionally appointed, then the traditional processes would be followed, just as if it were at large. But the only difference is that the person that would be elected, because I believe the next step is a call for an election.
I'm sorry, to call for an election.
Sorry. So if I'm trying to remember my provisional appointment steps here. So if there's a provisional appointment and there's no one that comes forward, then I think it goes to the county. But essentially, whatever happens, I don't want to go over my skis on that analysis. Whatever happens, the person does have to come from that trustee area. And it's an issue that we have seen in the smaller Central Valley districts, where there's a little bit more of an effort that needs to be made to seek candidates for those provisional appointment pieces. I haven't yet seen it in the larger districts, but that doesn't mean it's not something that may or may not happen.
Okay. It's not surprising this law came from California because it's kind of in line with a lot of recent legislation, but although this is not new. I'm just curious, what is the difference between the mayoral position and a board president if the mayoral election can be at large? I don't understand is that something specifically with Ed Code? I mean, it doesn't make sense to me.
And again, I'm not sure of the answer to that question at this point. I can certainly look it up, but my guess it'd be something separate, some separate ordinance or city code that applies to them.
So it's actually it's an office and statute. So the mayor is its own election. So the electoral. So if you're on the city council and you can run for office for mayor, it's its own elected office separate from the.
Well,
But there are lots of places that are not like that.
Right.
yeah, you're talking about a strong mayor versus
Our
a.
president we don't have someone run for board president. If we did it, I don't know. If
I don't think why you couldn't.
Well, I guess my point, we don't, but I'm just, because here's my concern. So now you've got 7 people who all, I mean, theoretically, we're making decisions that affect the whole district. But as has been brought up tonight, what's realistically going to happen if you take the Markham situation, which they were allotted, $20 million, I think, in Measure A, which was grossly below what was needed by the time we got there, and escalation, everything else. We took a lot of additional money to put in to make sure that school community had what they needed, because $20 million wouldn't have done that. If you have only one person who's elected by the people in that area, who else is going to give up money that might be going to their constituency? I mean, in essence, it means that you actually have a lack of equity. So at least to have one person at large sort of makes some sense to me, and that's why I don't understand why we couldn't go to that, because really in the school district world, I mean, even though we rotate it and things like that, really the mayor and a board president isn't that different. I mean, there's no voting differences. It's just procedural issues with meetings and agendas. So do we know for sure? Is there a way we could research? I don't know if that's something that the board would choose to do, but it would be nice to know if that's an option, because I don't think that people understand the negative impact that can have. I think in big districts, like when you're talking about, LA and huge places, it makes a lot of sense. And if the legislature would have put a population number on it, I mean, because realistically with 7 people, you could end up with 1 or 2 schools in your area, and that's what you represent. That's what your constituency is, or potentially, I guess, none, depending on how the boundaries line up. So if you don't have the ability to have an at-large board president, then, I mean, I just don't understand how anything ever gets done.
Mm-hmm. And we can certainly look into that. Right now, I'm off the top of my head not aware of anything that would allow the district to do that and also guarantee full protection under the CVRA. I'm not precluding that. It just, on the top of my head, I can't think of anything.
It would just be nice to know if that's an option, because at the end of the day, I think for me too, and I don't mean to keep beating a dead horse, but I think this is an important issue for us, and it's an important issue for the community because, you know, at the end of the day, what's really frustrating is you've got the state basically taking the right of the people to vote. You're saying, oh, well, the statute technically says you can vote, but we're going to trump that. And I guess my other question too, so this attorney that sent the letter, he's not a local attorney, right? He's not.
I believe he's based in
right?
Southern California, yeah.
Okay, so probably this attorney couldn't point Vacaville out on a map, right? I mean, except for that's where the check's going to come from. It's pretty much, anyway. Okay, I'm done. Mr. Whitman?
The other thing is, this isn't just going to cost us $30,000. I don't know what your attorney's fees are. I don't know what the demographer's fees are, but we're going to spend a couple $100,000 doing this at least, and we could pay for 2 teachers, a bunch of paras, all kinds of other programs if this wasn't being imposed on us. Thank you.
Okay. I think we're there because I don't think anybody has anything else to say. So, with that, thank you very much. So the recommended action is to vote for the resolution declaring the intent of the district or the board to transition to at-large districts to by-trustee area, from at-large to by-trustee area board elections.
I'll make the motion.
Motion and second? Yes.
What did you say?
Just comment on the motion.
Oh, okay. I didn't hear you.
Yeah, it's fine.
You can do whatever you want.
Well said. And this is a roll call vote, so.
Okay, I have Mr. Kitsis as the motion. Was it you, Mrs. Stacy, that made the second? Okay, thank you. Okay, Mrs. Stacy, your vote, please.
Yes.
Mrs. Dowley?
Yes.
Mr. Whitman?
Yes.
Mrs. Malberg?
Yes.
Mr. Kitsis?
Yes.
And Mr. Wyndham?
Yes.
Thank you.
Thank you.
Thank you, Mr. Tung. Great job.
Yes, thank you.
So Jane, put me in my place if I'm wrong. I wanted to wait till after the vote for next steps. I do want to put a request on the next agenda or some kind of a meeting for us to discuss if we wanted to, as a board, take on an advocacy role or a second resolution, just by majority or not, and have a discussion. So not to undo what we've done tonight, but in tandem or parallel work in advocacy.
Are you talking about to the state legislature?
Yes. But I want it agendized if possible, please.
I agree.
So if by majority we wanted to lobby, advocate, you talk to, write a resolution to the state, just take a stance on how this is affecting. Yeah, against it. Like not to not do it, but to have an opinion of how we feel like it's going to impact our students. So we'd have to do that by majority if we wanted to make it official. So I figure it needs to be on the agenda.
Yeah. Okay.